there are a lot of moving parts here still to have finished up, along with the depositions that we intend to take in order to prepare us for trial and to be ready for trial in November. So, Your Honor, we are trying to get ready for this trial date, but based on the number of depositions that have to take place, even if plaintiffs' counsel waives the right to take the depositions of our experts, it doesn't seem feasible at this time.
I'd like to respond to that.
I'm going to go back to what I said before. I just think this motion for continuance is kind of premature. We just don't know. This is set on the 14th, I guess.
Right.
I mean, I do think it seems like you're kind of cramming everything in rather quickly. But I mean, I've seen that happen before. Sometimes it works out, sometimes it doesn't.
Why don't you wait till the week before trial and give him the opportunity to refile it then, and we can see where we're at. But Your Honor, everything, absolutely everything. John's a good guy. I like John. He's very professional, but every issue that came out of his mouth, we've already dealt with, every single one. We, on his Geico DWQ, which is what he was referring to the other rec, we already have agreed literally to the terms of that. We have a Rule 11 on that. It just hasn't been signed by both sides. That's done. With regards to all these other depositions, we went through, agreed to all these dates, and I even told him, look, I'll even get new dates if for some reason they don't work out for you. We agreed to that. The only thing we're really waiting on in terms of this, I mean, it sounds like a really complicated thing listening to John, but it's not. Noticing a corporate rep deposition, we can give topics later on today after we know how you're going to rule on his motion to compel. If we get more documents, there'll be different topics. If we don't, then they won't. It's really that simple. It's not complicated. There's absolutely no reason whatsoever at this time to grant their motion. So can you deny it and give him the opportunity? If
no, I'm just going to pass it.
All right.
So we'll pass it, and you can re-raise it. You know, my inclination is you know, if you can get the discovery done, this is not a new case at all. So to allow it to go forward, but you know, if let's say plaintiffs, one of their experts has a family emergency and isn't able to, you know, give their deposition, there's just a lot of things, a lot of moving parts that have to go right for this to be ready for trial. But assuming they all go right, I could see it being ready. I don't want to deny it or grant it until we figure out what's going to happen. And I do think it's that's why I think it's premature. So, and then I looked at the order you provided. There's a lot of stuff in here. I'm really shocked that you guys haven't reached an agreement on. Have you conferred on every one of these?
If we're talking about the motion to compel, I can explain that, Your Honor.
Yeah.
Here's the issue. And again, I don't want to throw John under the bus here, but John has actually been very professional. It is not him, but he's working for a company called UPS. And UPS will not give him authority to take off objections to even something as simple as who are the people at the accident scene. I mean, there are what are the insurance policies that cover the incident that's been sued on, and so forth. He can't remove the objections. And so the consequence of this, and I've had these hearings before, not with John, but with lots of attorneys just like John, who are in a position where the corporation will not allow them to remove objections. And so here's what happens. They'll produce, let's just use an example, a few hundred or few thousand pages, and then all the stuff that we would actually want under the same categories, because there's an objection there, they have a legal right to withhold it under our rules. When we go and get the motion to compel, John's, able to send that up to UPS and said, hey, look, I did my best. An order comes, and then all of a sudden, there's hundreds and hundreds of pages more. I literally just had one where we were given thousands of pages in the identical situation. We then got approximately initial
three. I get it. Mr. Mulder, is that correct? Is that the situation? Is this, I can't believe, are you not able to withdraw any objections?
Your Honor, there are plaintiffs have raised a number of issues with nearly every response that we gave, despite the fact that we have supplemented documents in insurance policies. We've supplemented insurance policies more than enough to cover this claim.
Mr. Lansworth, are you able to withdraw objections? That's the question.
I am not, Your Honor.
Okay, we'll handle these other two hearings and then I will go through this very quickly. So you guys wait around and we'll get to the other hearings and then we'll come back to you guys.
Very good. Thank you, Your Honor.
All righty. Let's go to, is everyone here for, shoot, okay.
Están hablando.
Is everyone here on the Kid versus Walmart stores case?
Yes, Your Honor.
Yes, Your Honor.
All right. All right, is this the one on the guardian litem issue?
Yes, Your Honor. This is a friendly suit. We settled. This is David Johnson. I represent Walmart. We settled pre-litigation. I filed the friendly suit. Ms. Bradshaw has been appointed ad litem. It's my understanding, and Brenda, correct me if I'm wrong, but that she's still looking through documents and hasn't given her approval yet as to the settlement.
We were getting additional documents from the school and medical records, and we obtained those documents at the end of July, beginning of August. And then I submitted those documents to Ms. Bradshaw. We've had a few conversations back and forth. We were also trying to get additional school records that we were not able to obtain. So at this point, we have all of our evidence, and we're just going back and forth to see, if the settlement would be approved by the ad litem if she deems it appropriate.
Ms. Bradshaw? We can't hear you, Ms. Bradshaw. Ms. Bradshaw, are you there? We can't hear you.
I can't hear
Do you
you.
want me to call you? Do you want me to call? I'll call you. Sorry.
Hello.
Yeah, so this has been going on for nine months. What is the delay?
We still can't hear you, Stephanie.
The delay was the additional records that the family was trying to obtain, which we obtained those at the end of July, beginning of August. And then we were still trying to obtain additional school records just to make sure before the incident how she was doing in school. We weren't able to obtain those. So at this point, the ad litem and I had discussed, and we decided that we were going to move forward with just reviewing the evidence that we have. I don't know if Mr.
Move this
Bradshaw
up on Friday or Monday, because you have a trial setting next week. This is Friday would be in person. I don't know when Miss Bradshaw's out of town, or Monday would be remote.
Your Honor, we haven't, as far as trial goes, if the settlement is not approved, we would request a continuance of the trial. I think we filed a motion in that regard because we haven't conducted any discovery. There's been no disclosures. This has been operating as a settlement friendly suit. Let's try to get everything we can to Ms. Bradshaw so she can approve the settlement and then present it to you for approval. But if the settlement is not going to be approved, we would request the trial setting to be moved out so we can conduct discovery and get this case in a position to try it.
I'm not going to force you to trial next Tuesday. I don't want to, but I want to have that as kind of, I want to get this done or not done. It's not fair to you, Mr. Johnson. It's not fair to you. We need to get this done one way or the other. And so, so are you guys at a point where you guys can prove this up on Monday?
We still can't hear you, Stephanie.
Ms. Garcia, do you want to call Ms. Bradshaw?
I can call you again. Okay, she's on.
Your Honor, when I got involved, it was my understanding that there was not a agreed settlement, that there were settlement discussions. Since then, I've spoken with the grandmother, and I've learned that from Ms. Garcia that there was a verbal agreement regarding settlement, but that since then the grandmother has had concerns about the amount of money that the settlement is for. The child has had a neuropsych evaluation. There's this very mild traumatic brain injury case. I wanted to confirm a few things in her medical records as well as the school documents based on things that were in the neuropsych evaluation. And so I wanted to take time to do that before we approved the settlement. I have since learned, like I said, that there was an agreement from the grandmother to the settlement, but she's since kind of waffled, thinking that there has been some ongoing issues with the child. And I wanted to just dig in a little bit further and look at that before we confirm the settlement.
So let's just have a stat. Let's do this. We're going to have a hearing on Monday with the family on Zoom. We can do it. Rhonda, are you there? Let's do it at 11 next Monday. If the child's in school, how old is the child?
She's almost 10.
And
Don't you mind?
so I don't think the child needs to be here, but the grandmother will need to be here. Is it there's no parents, it's just the grandmother?
So I looked again at the custody or arrangement between the parents. We will need to have the mother and the grandmother present because they have joint conservatorship over the child. So they've got to jointly make a decision. That was another issue in the beginning. She lives with her grandmother. I think on a day-to-day basis, grandma makes just important decisions regarding the child. But from a legal perspective, the court's documents state that the mother and the grandmother have joint conservatorship.
Let's try to get both of them there if we can then. So we'll do this next Monday at Zoom. And Mr. Johnson, I don't want you to spend the weekend getting ready for trial.
Right.
But I will say this: if the grandmother, for some reason, we can't prove this up, I'm not saying we can't, then we are going to set it for trial.
That's fine.
But I want
Your Honor, just so you'll know, I think I'll probably have Helen Emerson cover that hearing because I'm going to be out that day. But
okay.
I can have her.
Is she familiar with the case and knows the schedule?
She is.
Will she be able to pick a trial date? That's what the main thing I'll be concerned about if we don't get it done.
Yes. Yeah. She'll have full authority to do that.
So if you can, let's get this proved up next Monday. If you can't, then I want to hear from the family that they don't want to settle this, and then we can punt this to trial.
Very good.
All right. So Monday at 4, next Monday, sorry, not Monday at 11, sorry, next Monday at 11.
Very good.
All right, and make sure the family's here. And Rhonda, put a big thing in this cannot be canceled without court approval.
Got it.
All right, guys, let's get this done.
All right. Thank you, Judge.
Thank you, Your Honor.
Thank you. All right, our next case is Martinez versus GV Construction Modeling. Are both sides here in that case?
Good morning. This is the receiver. I'm present. This is Dana Lipp.
Pete Rose present for the plaintiff and judgment creditor, Jesus Martinez.
For defendant and judgment debtor, Abigail Velasquez.
Is your camera on, Mr. Velasquez or Mr. Velasquez? There we go.
Is it on now? I can't see myself.
Yeah, we can see you. Yeah.
Okay.
All right. And Mr. Rowe, are you here on this case too?
Yes, Your Honor, for the plaintiff and judgment creditor, Jesus Martinez.
Sorry. So everyone I have spotlighted, is that everybody in the case?
I think Nick and Jesus Martinez may be labeled as home.
Okay, they need to turn their camera on. All right, let's go on the record on cause number DC 1919003, Jesus Martinez versus GB Construction Remodeling LLC. Counsel, make your appearances.
Thank you, Your Honor. Pete Rowe for the judgment creditor and plaintiff, Jesus Martinez.
Juan Garcia for defendant and judgment debtor Abigail Velasquez.
Dana Elip for receiver. I'm the receiver.
Who said I'm the receiver?
This is Dana Lip. Can you see me on the?
Yeah. Sorry, it sounded like two different people speaking. All right, let's go ahead and proceed.
Yes, Your Honor, we're here today. I am requesting an order authorizing the sale of non-exempt real property to satisfy the judgment and also to declare a general warranty deed filed by Ms. Velasquez on the same property void, attempted conveyance of the property as an unauthorized transfer of property in the custody of a receiver. So there is an unimproved lot of real property. It's non-exempt property. I engaged a realtor and listed it for sale. We received 3 offers. 2 of them were very similar. I took the best offer, which was for $105,000. $5,000 earnest money has been received. Closing costs are being paid by the buyer. There will be enough proceeds to pay off a delinquent property tax judgment. There's also 2 City of Dallas liens on the property that will get paid off, and then the judgment will get paid off fully or in large part. So I wanted to get the court's approval to sell this property and then also to declare void the deed of Ms. Velasquez trying to transfer a 90% undivided interest in this property to a Mr. Rodrigo Garcia, who I think may be also a named defendant in this lawsuit, but for which the judgment was not rendered against him.
Response?
Your Honor, judgment debtor is opposed to the motion for sale, specifically when it comes to the notice of seizure that's sent out by the receiver. There's a 17-day period in accordance to Texas Rule of Civil Procedure 679A, where there's a 17-day period that you have to give the judgment debtor to basically respond, and the receiver can't take any action. The property at issue was entered into a contract for sale on August 13th before the expiration of those 17 days, as well as before the expiration of those 17 days, judgment debtor sent over a settlement offer for approximately $56,000, including $45,000 to be paid off to the judgment creditor. There's exhibits that have been attached to receiver's reply to defendant's response to her original motion for sale, where the judgment creditor has demonstrated an agreement to accept $45,000 in settlement of the judgment. Judgment debtor has made this settlement offer. We haven't received a response from the receiver in regards to the settlement offer. Because the property is now under a contract for sale, judgment debtor is basically lost the property, hasn't been able to resolve this issue, make the settlement payment that's been offered, or receive a response to the settlement offer that's been made. So we're asking the court to deny the motion for sale so that judgment debtor can resolve the issue directly with the creditor. We've also made an offer for the attorney's fees and the receivership fees. And again, like I said, we just haven't received a response to the settlement offer.
Okay.
May I?
Response?
Yes. So There was a 679B notice, which was given, mailed on August 2nd, and it has not denied her from asserting an exemption for the property. No exemption was asserted. The property has not been sold. Everything was complied with. There was no hearing for a trigger on any exemption claim, and the burden of proof is on Ms. Velasquez to assert an exemption and to prove an exemption. The requisite suspension period has been satisfied because the receiver, I've not closed, not sure what just happened.
Is this rule 679A that you're talking about?
Yes, 679A and 679B. So the requisite statutory suspension period of 17 days because service was provided by mail will have been satisfied as the sale has not closed, and it will not close until at least court approval has been granted. Now, as far as the settlement offer, I initially started receiving correspondence from a different attorney who was going to submit a written offer and never did. Then I started receiving correspondence from Abigail Velasquez, from Mr. Garcia, from also an associate of the judgment creditor. And the judgment creditor corresponded with his counsel that he was not accepting a $45,000 settlement. He wanted $45,000 net, and a $45,000 settlement would not be sufficient as a gross amount to be received. So it would take.
So what was the amount of the judgment? 45,000?
No, the amount of the judgment is 69,900 or 69,700.
And then they offered 45,000?
They offered 45,000, which the judgment creditor did not want to accept unless that would be what he would net after all the receivership fee expenses and additional fees from creditor's counsel. And so I received an email to that effect.
Okay, Mr. Garcia, response?
Yes, Your Honor. The settlement offer that was made is 45,000 to plaintiff, the judgment creditor, and then an additional 5,000 in attorney's fees and 12,935 with 38 cents in receivership fees, plus 2,000 in receivership expenses and a $15 wire transfer fee.
I mean, I can't force you to settle, but does the creditor understand that? That was the offer?
Yes, Your Honor. We have had multiple correspondences, as Ms. Lipp noted, since the court appointed her as the receiver in this matter. I don't believe that there's ever been a firm meeting of the minds. And now where we are is that Ms. Lipp gave notice. She came into possession, or she seized the property on 1340 Amos in Dallas. Shortly thereafter, she gave the notice. Notice was noted that it was given on August 2nd of 2023, and that was noted by Ms. Velasquez's response filed in this motion. So the receiver has complied with 679A, 679B. Ms. Velasquez has been given ample opportunity to assert an exemption if one was available to her. She has not done this. We have this piece of property out here. It's under contract, and I'm not aware of any other property that will more completely satisfy Mrs. Velasquez's judgment debts to Mr. Martinez other than the sale of this property. So we would ask the court to approve the sale as requested by Ms. Lipp.
Mr. Garcia, it does seem like she complied. It says that you must not, assuming this is correct, I just found this on the internet because that's not in my rule book here, is not up to date enough to see this newest amendment. Unfortunately, receiver must not disperse funds to judgment creditor or sell property within 14 days after serving judgment with the notice of protected property rights, the instructions for property rights claim form, and the protected property claim forms approved by the Texas Supreme Court within 17 days if the service was made by mail. so during that 17 days after August, whatever it was, 2nd, your client had to, I don't remember 2nd or 3rd, 2nd, I think, had an opportunity to assert an exemption, which it sounds like they didn't do. I'm not sure what you're feeling that what the receiver did incorrectly.
Well, Your Honor, the property was under a contract for sale, and then we did not receive a response to our settlement offer, which is largely what judgment creditor would be accepting.
Okay. I will go ahead and I mean, is there any chance this could settle the plaintiff's attorney? Do you want me to go ahead and sign this, or do y'all want me to put you in a breakout room and see if you guys can make one last chance to try to settle this?
Your Honor, I believe under the circumstances, the receivership estate and my client are both best served by approving the sale. We have a willing buyer at what appears to be a fair market price, and it's going to fully satisfy the judgment debts that's owed. And if it doesn't, it's going to come very close to it.
Okay, then we will go ahead and approve it then. I will get that signed today. All right, anything else, guys?
Nothing further, Your Honor.
No,
Just-
thank you, Your
Can
Honor.
I say something? This is
Who is
Abigail
this?
Velasquez. Abigail Velasquez.
Do you have an attorney?
I do.
I'm her attorney, Your
Mr.
Honor.
Garcia.
Not usually, but if you really want to, you can.
Well, I just want to say, Mr. Martinez came to an agreement that he would take the 45, which was net. And on top of that, we would pay the attorney fees and the receivership fees. So I don't understand why the creditor doesn't have a say in what he was accepting. Because Mr. Martinez, we spoke to Mr. Martinez and he said he'll take the 45 on top, just
Well,
his fees, and then
if-
on top
if-
pay the rest, whatever the fees were.
If I recall, at the time that offer was made, I think that was made by a Mr. Rios, who's not even a judgment debtor in this case. And that offer
But he-
wasn't approved by Ms. Lip anyway. So we would just like to go ahead and have the court approve the sale, Your Honor. And also,
Well,
also
Mr.
declares-
Martinez-
And let me just ask this, Mr. Garcia, did you ever assert a breach of contract on the settlement agreement in your pleadings?
In our response to the
No, in your
receiverships,
plea,
no, Your Honor.
in your answer that's been filed in this case, have you ever asserted, or have you asserted a counterclaim that a settlement has occurred in this case and that the other side is breaching the settlement agreement?
No, Your Honor, this is all post-judgment. My appearance is post-judgment.
Yeah, I mean, so what would have to happen, Ms. Velasquez, is that if your remedy here would be to assert a counterclaim to say, look, there was a settlement in place, you didn't live up to the terms of the settlement, and therefore you're in breach of contract, but your attorney hasn't asserted a counterclaim for breach of contract. So at this point, there's really nothing I can do. Does that make sense?
Yes.
Okay.
And
But
Your
even the
Honor,
price on the property they're trying to sell it for, it's not a fair market value. If you look around in all those properties, there's more properties that are being sold, vacant lots that are smaller than the one we have there for $300,000. So I don't think $100,000 is even a fair market value.
Has that been pled in this case?
No, Your Honor,
Yes,
there
Your
have been
Honor.
no pleadings aside from the response to receiver's motion.
Ms. Velasquez, that hasn't been pled either. I can only consider what's been pled. I'm so sorry. Did you have any other questions, Ms. Velasquez?
No, I mean, if it's Martinez, the creditor that I owe the money to, he's saying he'll take the 45. I don't understand why he doesn't have a say in this, or why didn't he show up to court and say, yes, I did tell her. I've gone to other courts wherever I had to pay someone $5,000 because of a saying that they told me. So I'm kind of upset because the creditor did tell me he'll take the 45 and that he signed something approving the $45,000.
There was never a written settlement agreement signed by my client, Your Honor, and moreover, any agreement would be subject to the receiver's approval.
Well, I did try to contact her a couple of times. That's whenever I emailed her because I didn't have an attorney because my prior attorney, Katrina, I can't remember her name right now. She said that she tried to contact her and she wouldn't get no response either. So I was like, okay. So I felt like we weren't going anywhere. That's when I spoke to Mr. Martinez myself. And so Ms. Katrina wasn't representing me anymore. So I spoke to Mr. Martinez directly.
Ms. Velasquez, though, none of this has been pled. None of this is before the court. I can't just, this is a court of record. Maybe you dealt with JPs, but I only can consider what's been pled by the parties. Your attorney and you have not pled any of this. And so I can't consider just what you're saying here. It has to be pled. So I'm so sorry, Ms. Velasquez. All right, I've signed the order approving the sale. Anything else today?
No, sir, Your Honor.
No, Your Honor.
All right, you guys have a great rest of your day.
Thank you, Your Honor.
Thank you.
Okay, let's get back to the Hernandez versus Cervantes case. You guys, unfortunately, I'm going to just go through, let's see, Mr. Mann, I'll spotlight. And then there's a person here with the Nagwowski firm.
Right. That's
Is that your co-counsel?
he's co-counsel who brought our firm on recently, Your Honor.
Okay.
Yeah. Good
right.
morning, Your Honor.
Good morning.
Yeah, I'll
Right,
click
so
on it.
I'm going to go through the, since given kind of the procedural history of this, where the defendant can agree to overrule any objections, I'm just going to go through the requests, and if there's any questions I have, I'll go ahead and ask, but otherwise I'm not going to need argument. So for plaintiff's first set of requests for production, United Parcel Service, request for production number 3, it's granted and the objections are overruled. Request for production number 85 is granted, the objections are overruled. Request for production number 5 is, why does it go from 3 to 85 to 5, Mr. Mann?
I did that on purpose, Your Honor, so that those are both related to insurance.
Okay,
They're
I
not
get it.
all over the
I
place.
just want to make sure we didn't have a typo.
Yep.
Request for production number 5. Is very broad. So I'm going to allow, I'm going to change this up a little bit. It says all documents setting forth the relationship between defendant Cervantes and United Parcel Service. This includes leases, which is okay. Employment contracts, okay. Independent vehicle agreements, okay. I don't know what other contracts there would be, so I'm not going to allow that. You need to be more specific. Agreements, again, not specific enough. Termination letters, that's okay. You can get that. Intent to hire, promise of employment, I don't think that's necessary. Job descriptions, that's okay. Company hiring guidelines for this position. So you have to provide for Cervantes's position. Company requirements and standards too broad. Personnel files too broad. Company retention guidelines too broad. Requirements, standards, memorandums, all the rest of it's too broad. So what I'm going to require is all documents setting forth the relationship between I'll say the following documents setting forth the relationship between defendant Cervantes and United Parcel Service. this includes all leases, employment contracts, independent vehicle agreements, termination letters, job description, and company hiring guidelines for Cervantes's position. Any questions about that, Mr. Landreth?
No, Your Honor.
All right.
Your Honor, we had delivered this. Are you writing this or are we writing this and going to submit it?
I'm writing this down and then I will submit this to Rhonda tomorrow.
Thank you, Your Honor.
Request reduction number 6. Request reduction number 7.
I'm sorry, Judge, I didn't get that. You blinked out just for a second.
Request for reduction number 6 is granted and objections overruled. It's granted with the limitation that this catch-all and any other matters relevant to employment is just too broad. So I'm taking that out. So modified. We'll take that out. Request for reduction number 9 is too broad. I'm going to deny that. Request reduction number 10 is too broad. I'm going to deny that. Request for reduction number 11 is granted. Objections overruled. Request for reduction number 16 I'm going to allow that, but only for the, well, we'll deter. I'm not, this is obviously just issue discoverability, so I'm going to grant that one. That may not all come in, but I'll grant that one. Request reduction number 20. To 48 hours before the collision is okay, and for the 12 hours after the collision. So it's granted as modified. That was request reduction number 20. Request reduction number 24 is granted. Request reduction number 28 granted and limited to the 7 days prior to the incident and 1 day after. That's the video clip. And that was request reduction number 28 is granted, limited to 7 days prior to the accident, 1 day after the accident. Request reduction number 29. Limited to 7 days prior to the accident and 1 day after the accident. '29 is granted. Sorry, 91 request reduction 91 is granted. 92 is granted, and objections are overruled. Request for reduction 42. Request for reduction 43.
What was 42? It cut out on this end, Your Honor.
I'm sorry, granted and objections overruled. Request for reduction 43. So 43A is okay. What is the difference between a work vehicle and a motor vehicle? What is that, Mr. Mann?
If there is a distinction, we want both. I guess that's why that was drafted that way.
Yeah, I'm going to take, I don't know what the distinction is, so I'm going to take out the work vehicle. I'm gonna say the motor vehicle in question. Motor vehicle type in question. So, for example, UPS has a policy involving forklifts that wouldn't be required to be produced because I don't think there's a forklift involved in this accident, right?
Right.
Driver safety is that's just too broad. Defensive driving is too broad. Number E, compliance with federal and state, that's going to be regarding how did this accident happen?
Commercial vehicle rear-ended.
Render.
Right, stop sign. Stoplight.
And what kind of vehicle was it? The defendant had?
I believe it's one of those brown UPS delivery trucks.
The package truck, that's what UPS refers to it as.
What kind of truck? I'm sorry, Mr. Landry.
A package truck. It's the brown square box truck you see in your neighborhoods.
All right, so E is going to be limited regarding the use of UPS package trucks. F, accident investigation, that's too broad. I don't know what that means exactly. Accident review boards, too broad. Determination preventability of accident. This it needs to be tied to this a little more. So F through K is going to be, those are all going to be removed. So just to kind of summarize, 43 is going to allow the operation of the motor vehicle type in question, copies of all policies and procedures, compliance with federal and state law regarding the use of UPS package trucks, and then you're just going to need to do more specific requests for the rest. Number 44 is granted. Sorry, yeah, granted as modified. 51 is granted. 60 is granted. 62 is granted. 67 is granted. 68 is granted. 69 is granted. 71 I've already ruled on that, so denied, that's too broad. 79 is granted. 95 is granted. 87 is granted. 98 is granted. 99, I think I've already ruled on this, but granted. 100 is granted, and 101 is granted. All right. Let's go to first set of interrogatory. Number 2 is granted. 3 is granted. 8 is granted. 9 is granted. 10 granted. 11 granted. 12 it's too broad, denied. The 14 is the objections are sustained. 17 granted. 18 is granted. 19 is granted. 21 granted. All right, for first set of production to Daniel Cervantes, request production number 8 is granted. 15 is granted. That was 25. 30 is granted. 37 granted. 45 is granted. 61 is granted. 65 is granted. First set of interrogatory, sorry, 62, I'm sorry, not 65, 62 is granted. And then first set of interrogatories, interrogatory number 5 is granted. Interrogatory number 6 is granted. Interrogatory number 7 is granted. Interrogatory number 8 is granted. Number 12.
So it goes 7, 9, Your Honor. There's no 8.
That's something, or sorry, 7 and 9 are both granted. 12 is granted. 14 is granted. All right, how long do you need? And what is this case set? This case is set for trial.
So it's set for a trial November 14th.
14, so that's about 2 months from now.
Right.
So you'll have by 9, 25, 23. So you have 2 weeks to get this done.
Understood, Your Honor.
And thank you, Your Honor.
All right, this will not be scanned in today. It will be scanned in tomorrow. But if you don't see it on the system by Wednesday, give Rhonda a call.
Very good. Thank you, Your Honor.
Yes, sir.
All right,
Thank you,
anything
Your
else we
Honor.
need to chat about, guys?
Thank you, Your Honor.
All right, guys, you have a great rest of your day.
You as well. Thank you, Your Honor.